Well, welcome everyone. We're delighted to have a really interesting panel today to talk about challenges in Indigenous rights advocacy. I'm Cassie Boggs. I'm a mining lawyer in Denver, Colorado, and I'm really thrilled to have two colleagues to talk about this very important topic. I think everyone in the mining industry realizes that mining company interactions with affected communities, and in particular, Indigenous communities around their operations, is one of the most important and challenging issues for mining companies to do successfully. It takes a lot of time, a lot of effort and expertise, and we have two great experts to talk about these issues today. Let me introduce quickly Dr. James Hopkins, who is the Associate Clinical Professor of Indigenous Peoples Law and Policy Program at the University of Arizona, and the Affiliated Professor of American Indigenous Studies and Latin American Studies. He's going to tell you a little bit more about his background. We also have Dr. Elif Faraha Laltika. My apologies for my mispronunciation, who is a senior law lecturer and a director of research and consultancy at Tumaini University Mkomazi in Arusha, Tanzania. They are both going to talk about this important topic, and so I'll turn it over to Professor Hopkins to sort of set the stage around Indigenous rights and what that means in terms of consultation and other issues associated with mining operations.
Great. Well, thank you, Cassie, and thank you everybody for joining us. This is going to be a great panel. My name is Professor James Hopkins, and I am an associate clinical professor in the Indigenous Peoples Law and Policy Program. I've been in the IPLP for many, many years now, almost 20 years, and I graduated from the University of Toronto. That's where I did my first law degree as well. And then I graduated from Harvard Law School with an LLM, as well as the Kennedy School with a joint degree in international tax. So how did I end up in this field? Well, I grew up in a small Indigenous community just north of Ottawa, where my mother's family is from. And so for all of my life growing up, I'd been involved in various aspects of the community's life. And really in my undergraduate career, the watershed moment was a crisis in Canada called the Oka crisis, which some of you might remember, but it was a crisis that involved 2/3 of Canada's standing army and put the country on the verge of having to invoke the War Measures Act. And so I was growing up not far from there. It's just near Montreal. And it was referred to as the long, hot summer. And that was a watershed moment for Canada because it brought into bearing the old, if you will, or lesser known constitutional reforms that had already been made with the growing Indigenous population and so many of the unresolved and unreconciled issues, and mining actually being one of them, a big one. So from there, I went on to law school. In Canada, you have to article for a year. So I clerked for a year in the Northern Circuit, which is in Northern Ontario. It's essentially like the district court circuit. And then I had articled at a large firm in Toronto, where I was able to gain direct experience with natural resources and energy law and Indigenous peoples. And then I was off to graduate school. So throughout my career, I've had opportunities to work in and around various projects that are constantly tied to the issue of mining and the rights of Indigenous peoples, both in the United States, Canada, prominently in Mexico, and in other international locations. So it's been a really interesting opportunity to, first of all, join panels with former students like Ellie. It's a great privilege and a great honor, and very, very excited to have you here. So thank you. But also to use this moment to reflect back on the landscape and how it has changed so dramatically. So if you look at the international kind of benchmark, 2007 is a very, very significant turn, if you will, in the development of international indigenous human rights law. Now, understanding prior to that, there were and are a number of regional human rights decision-making bodies that issued what is in effect jurisprudence on this topic that has also influence directly how mining companies ought to engage with and consult with indigenous communities. But 2007 is the year of the United Nations Declaration on the Rights of Indigenous Peoples. And simply put, this is a very quick summary, it had a great reception and great fanfare, but there was always this caveat that, well, it's just a declaration. And there's been a number of articles written about this since to really educate the readers to the intensity of the work, the amount of consultation that went into it, and the role of international customary law. That debate is really not a debate anymore. You will see UNDRIP, as it's called, being referenced in state and local laws in the United States, not very often, but it's growing. In Canada, you'll see, for example, the province of British Columbia passing legislation to enact the goals and objectives of UNDRIP to be UNDRIP compliant. And likewise, you'll see the same with the federal government of Canada. And here's where it gets interesting. And this is sort of a thematic segue into our discussion today. So you could say, well, based on what you've just said, Professor Hopkins, you have these there's many boxes or jurisdictions in the world, and you just ticked off two of them to say they're UNDRIP compliant, or they're trying to be. So what's the issue? Well, UNDRIP is quite expansive. It has a very lengthy preamble, that's deliberate. So there's lots of really interesting and important rights that are highlighted and protected in that preamble, but as well, there's 45 articles to it, and a number of them directly address the need for consultation and consent based on the free, prior, and informed standard. So if you're in the mining sector, that is a huge issue because that standard will fill in the gap where domestic legislation leaves open any gaps. So that's something to be aware of directly. And then finally, more practically speaking, for example, in the case of Canada, there are so many Canadian mining companies that accrue much of their wealth outside of Canada that they have also had to look and consider seriously their roles vis-a-vis sustainability, social responsibility, and human rights compliance. And in fact, the Supreme Court of Canada has opened that door up directly in one decision about 3 years ago now, where it held that a Canadian mining company was held accountable or could be accountable for customary international human rights standards in the case of employees, former employees who had been working for the company in Africa who were subject to torture by independent security forces as well as state forces. And so this creates a big conundrum, right, for mining companies, because on the one hand, you walk into a situation and you're just the permit holder, for example. And one argument or one take is, well, we just have the permit. We've gone through the process. So we ought to just expect that we need to begin. In fact, some permits put you under that obligation. Well, it's now, as you probably can tell, it's now more complicated. And so mining companies are in a very unique position because the systems generally kind of leave them on their own to some extent, with some measure of autonomy to some extent. And just the fact that they're the ones who are holding the permit and want to develop the site, it puts them in a very important leadership position in that process. And so for those reasons, mining companies must take this seriously. And we have many, many examples of the consequences that can occur when they don't. And so in that regard, UNDRIP has moved, I think, from a place of aspiration to codification. And I think this will be thematic to mining as we go into the future, because there's a huge social policy aspect to this. And what we have seen since 2007 is mining companies voluntarily taking on standards, both in terms of sustainable development and community engagement, that thematically fit with the binding aspects of UNDRIP, or how it's posited into domestic law. And so that's another area to be sensitive to. And this finally has also connected with and flowed into the role of third-party lenders and financing. And so Canada is another example where regulators are more concerned now, particularly in the penny stock area, of how those companies are able to acquire their permits and fulfill their obligations globally. In other words, there's more scrutiny both from lenders and regulators as to how a mining company is promoting itself and conducting itself to make sure that it's a good global citizen. Some of you may already be familiar with this, but there are many examples on annual shareholder reports that reflect this shift. So that's a very, very quick general overview of the landscape that we live in today. I will also say that this comes at an enormously important time. There's always been, for the last, I would say, 8 years, discussion about the approaching energy crisis vis-a-vis global demand, namely that if you juxtapose the needs of the United States with China, the latter's demands really are growing every year. This was thematic to many of the conferences and papers. Well, now we have a new challenge, and it's just as real, and that deals with the shift from combustible engines to electric vehicles. And we can see already, I can see in my profession, the seeds of future discontent, where there's such a huge rush, whether it's for lithium, nickel, or cobalt, in light of the incredible shifts in policy at the federal and state and provincial level, as well as the manufacturing level, to obtain these scarce resources. And so this issue will only become more and more prescient. So on that note, it's a great privilege to turn this over to Ali to get some of his perspectives on his experience in Africa, and to reflect a little bit on UNDRIP as well. So with that in mind, Ellie, I hand the baton over to you. Thank you.
Thank you, James. Hello, everyone. Yes, so as introduced, my name is Elifuraha Laltaika, or Dr. Elifuraha Laltaika, and I'm a senior law lecturer at Tumaini University, Makumira. That is an institution based in Arusha, for those who know northern Tanzania, and it is owned by the Lutheran Church. And I am very glad to be invited as a speaker to this conference, because former student of the University of Arizona and a very proud alumni. Professor James Hopkins was my teacher in the area of mining and natural resources more broadly. But after that, I also went to Harvard as a visiting scholar, where I examined rights of local communities and indigenous peoples in the extractive industries. So how the extractive industries, affect their rights to land, environment, and the livelihoods more broadly. And I looked at that from the international law and also comparative legal perspectives. And to be precise, I was much more interested in looking at the UN guiding principles on business and human rights, and how that set of important standards can be implemented for the benefit of local communities, but also not to affect investors who want to some returns on investments when it comes to the businesses in the continent. And after that, I served, and I think that's important to mention in connection to my presentation, I served as an expert member of the UN Permanent Forum on Indigenous Issues. This is a high-level forum reporting to the United Nations Economic and Social Council, or ECOSOC, and it has broad mandated areas. And what we do, at least when I was a member, was to advise the UN system more broadly, all agencies and programs on how to implement indigenous people's rights, and also indirectly advise governments and set how to interpret certain normative frameworks that the UN establishes as minimum standards of treatment for indigenous peoples. So without any further ado, allow me to talk a little bit about the presentation, which really focuses on perspective from indigenous peoples and local communities in Africa with regards to some challenges to mineral resource development, and probably by way of framing my presentation, it's important to talk a little bit about the distinction between indigenous peoples and local communities. I think colleagues in the field have heard about that dichotomy, and so it's important to highlight what that means. Indigenous peoples is already an international law terminology, so it reflects or it refers to communities that are already well established in international law. As James has mentioned, the United Nations Declaration on the Rights of Indigenous Peoples, which is quite a robust international legal document and communities that are distinct and they have their rights which are collective. On the other hand, local communities is a broader term that may include indigenous peoples, but it is only recently that it has acquired traction, and they are more robust. And there is quite some contestation because in some multilateral environmental agreements, like the United Nations Framework Convention on Climate Change, for example, there is a growing need to combine the two communities. And the acronym now gaining traction is IPLC, Indigenous Peoples and Local Communities. But there's quite some contestation among some indigenous leaders and scholars. And, the worry is that that may water down, may dilute the gains that have been recorded already with regards to the rights of indigenous peoples. And I think that is my position as well, that there are two distinct aspects. And the second thing that is important to highlight as I frame my presentation is the fact that the term indigenous peoples is highly contested in the continent of Africa. The governments refuse, that there are indigenous peoples within their borders, and I think this has two reasons. One is the connotation that once you start talking about indigeneity, the rights of indigenous peoples, you very contested and highly emotional aspects of priority in time. Who was the first to occupy a certain territory. And therefore, governments do not want to open up the Pandora's box, and therefore there has always been a very, very stiff resistance not to recognize any community in most part of African countries that they are indigenous. But despite that contestation, two important things have happened in the continent. One is, an endorsement, an agreement on the part of the African Commission on Human and People's Rights. This is a chartered body based in Banjul, the Gambia, that has the mandate to promote and protect the rights of indigenous peoples. So having examined the situation of communities in the continent that self-identify as indigenous peoples, the Commission came to a conclusion that in fact there are indigenous peoples in Africa, and that they have similar marginality or vulnerabilities, just as other communities that self-identify as such in other parts of the globe. And that endorsement was also, repeated by the African Court on Human and People's Rights. This is a judicial body with its seat here in Arusha, my own city, and in deciding two cases, in fact, it agreed that Africa has communities that qualify to be indigenous peoples as far as international legal frameworks is concerned. So the debate whether we have indigenous peoples in Africa has been settled if we are to refer this to important continental bodies. And it's important to highlight that the term indigeneity or indigenous peoples as used in Africa is slightly different, and that is a guidance by the African Commission. That primacy is given on the marginality of these communities that has survived the attainment of independence. So it's not about competition of who was the first occupant of what part of land, but really is looking at communities on the margin that live collectively. They occupy the land, and the land to them has enormous spiritual and cultural connection. So that's about it. But really, I should also mention that indigenous peoples, as I said, have already occupied quite some important spaces within the UN human rights framework. I mentioned in the beginning that I served in one of the body that is exclusively for the protection of their rights, called the UN Permanent Forum on the Indigenous Peoples. But there are two other mandates. One is the position of the UN the UN expert mechanism on the rights of indigenous peoples with its seat in Geneva, but also the position of the UN Special Rapporteur, and I think that is well known at the University of Arizona, because the IPLP, the Indigenous Peoples Law and Policy, is housing, is helping the current office bearer. So that is to say that there are institutions and normative frameworks that are specifically geared towards protecting indigenous people's rights globally. But what are the challenges really afflicting indigenous peoples in terms of mining or extractions of minerals in the continent? And in responding to that part of the question, I'll be using interchangeably indigenous peoples and local communities. But as I said, that is not in any way aimed at diminishing the fact that the indigenous peoples framework is already very advanced, and communities that want to use it fully aware that it is already a very strong platform for which to advocate for their rights, unlike the local communities, which is really amenable to a lot of restrictions by governments. So the first important aspect when you talk about mining and the rights of local communities and indigenous peoples is the aspect of consultation. And applied to indigenous peoples, it is referred to as free, prior, and informed consent. And why? Why is it a big issue in the context of mining? One is that local communities risk a lot of human rights violations if they are not consulted. One is forceful evictions, and some evictions are very technical. It's harder to know because some local communities do not occupy the land throughout the year. So operators may evict them, may restrict access to land, and therefore technically evicting them without knowing. So it's important to consult them, but also pollution of their drinking water, both for humans and livestock, destruction of farmlands and grazing lands, and the decimation of biodiversity. And as we know, lots of local communities and indigenous peoples are dependent on a lot of medicinal plants, and that is not out of choice. Sometimes they are forced to depend on medicinal plants because there are no dispensaries, given the fact that they live in very remote areas. So, those trees are the lifelines, that's what it keeps them alive. And it's just important. Justice demands that prior to establishing mining areas, it is important to consult them. But really, much more important in the context of indigenous peoples is the fact that land to indigenous peoples is not merely an economic asset where you can compensate them. Monetary compensation cannot really fully address their vulnerabilities and the cultural and spiritual connections which they attach to their lands. So it is important to consult them because of that nature. And I want to bring an analogy. It's just like demolishing someone's bank or ATM or dispensary. You see, it's important, or church, or any place where someone goes to pray. So it is important we consult indigenous peoples, because by doing that, we can have a full understanding of the intricacies of their land use, which is radically different from other local communities and individuals elsewhere. And the second important aspect when it comes to mining and indigenous and local communities' rights is the aspect of compensation. And when you talk about compensation, which is actually the epicenter of complaints and dissatisfaction, when companies go to invest in some parts of African countries, is the fact that subsurface resources in many African countries do not form part of the land. So land is defined in exclusion of subsurface resources such as petroleum and minerals and even natural gas. And what that means is that whenever those subsurface resources are discovered, communities would be required by law to vacate the land. And if they are lucky, they will be compensated. And therefore, that is really the starting point of the problem, because reflect the understanding of indigenous communities and local people. They don't understand why their wealth should be disregarded. The land should be defined in a manner that dispossesses them of a stake to the valuable resources whenever they are discovered. So I will talk about 4 factors connected to dissatisfaction. Why there's always a lot of complaints when companies go to invest and they don't really compensate communities well enough. Number 1 is a lack of realistic market value that ignore the intrinsic value that communities attach to their land. So what happens in practice is that the host government in a natural resource-rich African country would look at the market price. What that means is the value of land in the locality. So they would ask themselves, what is the price of land here? And to understand that, they will ask themselves the second question: when was the land sold in this village, for example? And once they find out, say, how much was the land? And then they use that as a basis to know what is called the market value. But that is quite a distortion, because local communities and indigenous peoples, to them, land is not for sale. They sell the land only when there is a pressing problem. For example, when a child has probably been hit by a motorcycle and they need to rescue, and so on and so forth. This is on occasion, on very, very few occasions, and therefore you cannot use a problematic situation as a basis for market value. So in my view, that aspect of market value that ignore the intrinsic value of the land, but also ignores the fact that land is not for sale, is the basis for a lot of dissatisfaction, because local communities and indigenous peoples do not feel that they have been sufficiently compensated. The second one is lack of understanding and over expectations. It's important to know that they can't understand. Probably this may tied to the fact that they are not consulted in the first place. So they have a lot of over expectations about what they should be given the fact that a lot of valuable resources would be extracted from their land. And therefore that brings quite a lot of dissatisfaction, connected to over expectations and what in reality they are willing or they are likely to receive. And in most cases, the compensations payable is not enough to really restore the livelihoods. And if you read and you talk to local communities in many parts of Africa, that is really their main satisfaction, that whenever the subsurface resources are discovered and they have to vacate the land, the compensation they receive is not only deviative, or it ignores the intrinsic value of the land, but is also too low to enable them to restore their livelihoods should they decide to relocate and go somewhere else. But the third aspect is really based on common sense. It's not commensurate to the value of the minerals that are extracted once the land has been taken. If you read a lot of laws of different African countries, they have quite an important clause or provisions that empowers the head of state to acquire the land for public interest. And I support that. If, for example, you want to build a road which is used by the whole public, you want to build a national hospital, and so on and so forth, because it benefits the entire community. And that makes sense to a lot of indigenous peoples and local communities. What doesn't make sense is this aspect of the commercial nature of extractive industries, and you tell them that it is for public interest while they know that a lot of money will be made. So this also, based on my research, is some sort of reasons why there's a lot of dissatisfaction around the compensation that is payable. But that's not all. There's quite a lot of other problems. But the elephant in the room is the delayed compensation. Once the land is acquired or is earmarked for extractive industry, a survey has been made or exploration, and it is established in the affirmative that there are minerals, commercially viable deposits, and therefore the land is suitable for extraction. But from that point until the compensation is actually paid, it takes a lot of time, and communities have complained that they cannot develop, they cannot put their land into any use. So there's quite a lot of losses that they encounter between establishing that there are commercially viable resources, that need to be extracted, and the actual payment of that compensation. I've seen quite some laws, including in my own country, that take care of that in terms of compensation, because it's computed to take into account some interest that and probably what the valuation of the currency that has happened when the compensation payable was established and when it's actually paid. But I think that is not enough, because losses are not only monetary. The suspense that the community undergoes is telling in terms of the disturbances that they encounter. And that really is one of the key issues. But I think an important part, as I conclude, is to also talk about local content and corporate social responsibilities. And I want to speak about this in connection to the UN Guiding Principles on Business and Human Rights that Professor John Ruggie developed, and they were endorsed by the UN Human Rights Council. That business communities are really, there's overwhelming expectations from communities that business entities should respect their rights. And one of the practical ways is to ensure that there are some economic gains that accrue to local communities. And there's no better way to do that than implementing in good faith aspects of local content, where goods are sourced from within the country, employment preferences is given to local communities, and also services such as accounting and lawyers are given, preferences given to local communities. But this is still, there's a long way to go because it needs quite some good faith on the part of the government, the investors, as well as the regulators. But it's an important aspect that, if well done, will help mitigate challenges in the mining sector. Of course, the other is corporate social responsibility, and I'm seeing quite a lot of countries that have taken this to a new step, where the corporate social responsibilities is made mandatory, and it's put in some legislative frameworks. But to conclude, these are my recommendations on what can be done. The first one is going beyond the national legislation. So a mining company investing in a country in Africa is much more advised to be guided by international standards that put the minimum standards expectations, of how local communities and indigenous peoples should be treated. So my advice is that they should not use national legislation as the framework, but they should go beyond and consider international frameworks, including what James has mentioned, the United Nations Declaration on the Rights of Indigenous Peoples, which while we say it's not binding as a matter of international law because it's a declaration, but it provides quite some strong normative guidance on the rights of indigenous peoples. But the other one, the second thing I would advise is for companies to conduct genuine community consultations, right? And there's quite a lot of developments now on the frameworks on how this can be done. And when it comes to indigenous peoples, the aspect is free, prior, and informed consent. So FPIC should trigger whenever land belonging to indigenous peoples is likely to be affected in any way, not only in terms of relocation, but if medicinal plants, sacred sites are about to be affected, it's important to conduct full, prior, and informed consent. And the third thing is, as I said, offering opportunities, economic opportunities to indigenous peoples and local communities, because that brings about the license to operate. Companies may enjoy the investment destination based on national legislation, but it is also important to avoid negative publicities and avoid misunderstanding with local communities and gain a social license to operate or legitimacy by treating local communities well, and avoid avoidable challenges or effects to how they enjoy their rights. And finally is the aspect of grievance mechanism. It's important not to rely on the complex legal system, which is prone to a lot of technicalities for communities to gain their rights. So it's advisable that investors should have, custom-made, tailor-made mechanisms of addressing any dissatisfaction at the level of the mine, and avoid them from escalating into conflicts that would affect the resources. In my views, if those are followed, we can have advantages on both sides. Investments, because Africa needs quite a lot of investments that will be developed. There are resources, but also is important to balance and respect rights of these communities. That's all, but in case there are questions, I'll be very delighted to respond. Thank you very much.
Dr. Lateka, that was a great discussion of all the issues associated with this, and I really appreciate it. I would like to ask you, as well as Professor Hopkins, about the idea of consultation and free, prior, and informed consent and what that means. I think responsible mining companies understand they have to engage in consultation. And I think the challenge for mining companies is, what does that exactly mean? When do you do it? How much do you do? When are you done? And I know in Canada, there is a framework that the government participates in those consultations and help the mining companies do that. Professor Hopkins, you can maybe speak to that. I think in Africa and lots of places, people understand they have to do consultation, but I would be interested in sort of understanding how to do that so that every mining company that comes in engages in a similar process that is fulsome, that balances the rights, and that results in hopefully an agreement, and how to do that. Because I think the challenge for mining companies has been, one mining company may do consultation one way, another company may do it a different way. And I think that is where mining companies sometimes stumble, because they're not quite sure what the framework or process is. So I would love to get both of your views on how mining companies can ensure they're undertaking sort of best practices in this area.
Thank you to my colleague. That was a great discussion and analysis of the situation in Africa. And it's a great question because it offers up an opportunity to do a comparison. So, for example, in Canada, it's very similar to the United States in that the special federal relationship overhangs all aspects of a mining company's activity, because the permit is issued by a sovereign government. So the government can't simply delegate away its responsibilities. But having said that, in both jurisdictions, it's become very regulated. What's interesting in Canada is because natural resources are a provincial matter under the Constitution, there is a variance from one province to the next in terms of how they deal with it. And in the beginning, in particular, the federal government tends to take a back seat because it's not viewed as their area of jurisdiction. At least traditionally, that's been the way. So Ontario's Mining Act incorporates the standards that we've just talked about in the permitting process itself. So the permitting process has long been established under provincial legislation. It's just now there are these extra add-ons in the process for permitting. So, for example, if a company has to fulfill the permit requirement to discuss and explain how it plans to close and remediate the mine at the end of its life, a closure plan, it needs to, in that instance, also incorporate the consultation and feedback and recommendations that it has received from affected Indigenous communities. And if you roll that back to the very beginning of applying for the permit, the application process necessitates consultation at the beginning. So it's a system that takes the pre-existing permitting process and incorporates from the beginning to end the input of Indigenous peoples vis-a-vis consultation. Now, when we talk about free, prior, and informed consent, there was a lot of concern about this on the part of all parties when that was introduced. So the standard in Canada at a practical level, I think, works out into three different groups. The first, in terms of Indigenous groups participating in the process, the first will be the company casting a broad net, so to speak, because in the area, it has to include all Indigenous organizations and Indigenous groups. And so if, for example, however, the proposed site itself, the in situ part of it, is directly near to a First Nation and their reserve lands, and that those lands where the project is could be on what's arguably unceded or treated lands that arguably have rights reserved for the First Nations, that level of consultation is going to be much more intense. And there's going to be a greater emphasis on building a partnership with the First Nation. Now, as you might know, most of these projects are in Northern Ontario, and there's significant mineral resources there. So these projects are always long-term. They are massively capital intensive. And so it does provide an opportunity for First Nations to consider whether or not they want to partner with the company. And it's one beneficial aspect is that the permitting process also screens out the company so that you're only going to get into a permitting stage if you meet the standards. And so it's typically going to be the major mining players that are there. And so they have they have a shelf life to them. So one of the concerns early on, particularly in British Columbia, was the companies come in, they're speculative, and then they kind of bail early on once they've raised a sufficient amount of capital on the stock market. And so for the actual development part, you tend to see larger companies that want to have long-term relationships. So in that first context of a First Nations that's proximate, near to, it goes directly, I think, to what Ellie was talking about the needs for jobs. At this point, in this generation with First Nations communities, they're very, very concerned, rightfully so, on looking out for jobs, because as I think it is in the United States as well, as the First Nations population grows and they have greater access to education and get educated, the likelihood of them returning to their communities is directly going to be attributed to whether or not there's jobs. And so the viability of many of the First Nations, looking at the long term, can see some positive benefits with regard to partnering with a mining company. And I should also mention, so that's a whole area of practice. That's a lifetime of work, because many of these communities want to have business venture agreements, et cetera, but they don't have any capital. They need to have employment standards that are considerate of their own socioeconomic situations, as well as their own cultural and spiritual practices. So again, it takes a long time to build relationships between the mining company and First Nations to really get to know one another in that regard. The second, I would say the second category are Indigenous groups with an interest that are somewhat tertiary, that they're not in the proximate area of the development project, but they're kind of close enough. They could be by a major drainage system or even a major transportation route. They will be brought in as well into the consultation process, but it's also understood that their proximity will also reflect what the type of partnership is being offered. It creates an interesting dynamic, though, because you can actually have First Nations groups competing against one another depending on their capacity. So there are some First Nations that are just known already for having a kind of a leap forward in terms of their contracting ability, for example, with short haul and long haul trucking, things like that. And so there's an interesting dynamic within the Indigenous communities themselves about being mindful of who their neighbors are and how that can impact an agreement. And so from that, the third group category would be kind of like all other Indigenous groups, because Canada has 4 categories of federally recognized Indigenous groups. And so one group, for example, that you don't typically think of them as having reserve lands, is the Métis. And they will also be consulted, and it really depends on again the location of the mining site. But if they're in the area, if they have a regional organization, that Métis group will receive a notice of consultation. And so at the end of the day, all of those 3 categories, you can, if you're an Indigenous organization, you can try to kind of get off the freight train, if you will, and go to court if you're not pleased, or if you feel like your Indigenous rights are being trampled upon and abrogated. You can go to court under the process of judicial review, which is similar to the US. And so you're asking the court to review the government's fiduciary duty, including its duty to consult under the facts of the situation. That is becoming increasingly more difficult. I think courts are now more experienced with the mining process, and so they're going to be paying much closer attention to the nature of the right that's affected, and they're going to be looking more closely at the factual record to see, was notice given, things of that nature, some of the basic touchstones that would trigger judicial intervention. So it's becoming much more sophisticated in that regard. And really, just to conclude, the emphasis on the future and the economy have become front and center. And I think that speaks directly to a younger generation that has come up, and they really need to find a place in their community that can give them a good standard of living. So.
That's great. Ellie, maybe you can talk a little bit about consultation and of course, every country in Africa is probably different, but how mining companies try to manage that consultation process, or where should they be looking to try to understand what is an effective consultation process?
Thank you, Casey. And in fact, that's a very central question, the how, because as you correctly pointed out, there's no one size fits all. The countries are very diverse. And the Inter-American Court, in one of decision was of the view that even triggering FPIC is a matter of scaling approach or sliding scale approach, SSA, meaning it depends on whether the impacts are enormous enough to merit its triggering. So even the threshold of when should FPIC trigger is contested. There's no firm agreement, consensus globally on what should happen for FPIC to trigger. But already we have quite a lot of standards and suggestions and best practices. And one that I can mention already is IFAD, How to Do Not. IFAD is the International Fund for Agricultural Development, which has some, is one of the foremost UN agencies really when it comes to implementing FPIC, and it has a document on how to do it. It provides quite some comprehensive guidance on how FPIC should be conducted, in practice on the ground. But also the World Bank, with its new environmental and social standards, number 7 for indigenous peoples, it also provides. And the two things are important. One is the screening. It is important to conduct the screening first and be sure there are communities that self-identify as indigenous peoples and they meet the criteria. But in practical terms, we advise that whenever there is a doubt on whether the communities are indigenous or not, then the practice is to give the communities the benefit of the doubt, because that is also in line with environmental justice, where you really take care of harm before it happens, because it's hard to remedy the harm later. So it's important to give them the benefits of the doubt. But I've done quite a bit of that work for some clients in my capacity as a consultant, and I don't want to disclose here, but I should just say that what is important is to have good faith, to ensure that you are consulting indigenous peoples in good faith, and that you are sensitive to the cultural appropriate mechanism to do that, meaning you really go by the rhythms of the communities. You don't impose. Even timing is very important when communities, for example, is out for hunting or has taken cattle where there's available salt lake or grasses because of the challenges in the rangelands. So consultants can take care of that in a manner that really the bottom line is that it is done in good faith with the view to ensuring that should there be any impacts, then they are mitigated in a culturally appropriate way. Thank you, Keith.
That's great. I think we are just about out of time, and we want to leave some time for questions. So we will stop here, but I know this is a topic of great importance that we could talk for hours, so we'll look forward to any questions. Thank you.
Well, thank you, Cassie and James, for really an excellent analysis. Yeah, it struck me that the direction of our discussion really may boil down to the attitude or the laws within individual countries as to the rights that indigenous communities have as opposed to local communities. Is that because obviously the local communities probably have more input in or political control as opposed to indigenous communities that are maybe placed in a separate category? feel free to jump in.
Ellie, I think you're on mute.
Oh, yeah, sorry. Thank you. I think I'm audible now. You can hear me. Yes, yes, that's really an important aspect to talk about because it goes beyond mere identity and recognition. It boils down to the type of rights that each group demands. So indigenous communities are communities that have very strong attachment to their ancestral land, and their rights are usually collective. In the field of human rights, they are referred to as third generation human rights. They touch on the environment and they are enjoyed collectively. And in fact, in some parts of the world, the Americas and Australia, they really are the most prominent right they demand is some autonomy, self-determination. And this is very much different from demands of local communities, which is quite a term that is all-encompassing, and it is yet to be developed internationally. And in most cases, the rights that are demanded by local communities are individual. So even when it comes to land, not the collective enjoyment of the land in a manner that perpetuates cultural distinctiveness, but is just really the right to occupy the land on individual basis and have access to it, and probably have a certificate of ownership. And that's why I said in my presentation that there's a huge contestation among scholars of indigenous people's rights because they worry that if we conflate, if we are really confused between the two terminologies, chances are that we can erode a lot of gains that have been made already when it comes to the term indigenous peoples. So that's really the main distinction, that indigenous peoples have unique demands which are tied to their collective use of land and the need to survive as a culturally distinct groups in whatever country they live, in Africa, in Australia, in Canada, wherever, in the United States. That uniqueness and the survival as a collective is the centerpiece, is the lifeline.
Thank you. James, is that true for First Nations in Canada?
Yeah, no, it's completely true with the issue of Aboriginal rights that are protected under the Constitution, including treaty rights. The other thing I would just add to this, because this is really important, what my colleague has presented, is there's a history in almost every case between the Indigenous community and the quote unquote rural community. In jurisdictions like Ontario, like all of Canada, and certainly within certain jurisdictions in the United States that have a smaller Indigenous population within their territorial boundaries, there's usually some politicking locally, and some of it's just natural because the mining company wants to hire locally. Historically speaking, skilled labor or access to skilled labor has been a challenge in many First Nations communities. That's changing, but for the way the mining companies want to run and set up their operation within a time frame, they'll typically hire from the non-Indigenous population. And then finally, there's usually in those instances, local or state incentives to set up shop, so to speak, in that particular area. So I've been involved in a number of cases, both in Mexico, in the United States and Canada, where, as Ellie was saying earlier, this idea of good faith, it's not a good way to start a consultation on the part of the mining company if they've already been consulting and signing contracts locally, because everybody hears what's happening. They hear that the company is, pumped in $2 or $3 million of contracting and all these other benefits, and then finally, it's viewed as like, okay, so now you have to tick the box and cross the street to go talk to the First Nations population. So it's a really, really important point, I think, that Ellie mentioned.
What happens in countries that may or may not recognize the rights of the Indigenous community peoples? And I think that you hate to call them unsophisticated countries, but let's say that Democratic Republic of Congo? What happens there?
Right. What happens is that recognition by government is not a criteria under international law. International law recognizes that there is quite some contestation, and therefore, like any other right, is not tied to the government recognizing. So there is a set of defining criteria under international human rights law for a community to be indigenous. And the first and most important is self-identification. So it is self-identify as indigenous people, and it has to be recognized as such by other communities. Another is, collective and cultural and spiritual connection to the land that they occupy, and that aspect of being a distinct population in terms of language and cultural, governance system, and so on and so forth. But as you have correctly said, most governments really do not want to recognize indigenous peoples, probably for many reasons, including the aspect that probably they may open up the Pandora's box, and they are trying to build unity and have one nation, and they are afraid that fragmenting that may affect the broader need to have a national unity. But international law go beyond there because it recognizes that as a right, as a human right. And what happens is that if a company goes to invest, as you said, in DRC, there is an expectation from the global communities, including indigenous peoples and UN bodies, also, lenders, that they will respect rights of communities that self-identify as indigenous peoples, whether or not their host government, recognizes them as such. So the demand goes beyond the national framework, which may be tied to non-recognition, should not be a bar. The financier, lenders, IFC, and the other lenders would expect that a company should abide by international standards once communities self-identify as indigenous peoples.
Yeah, well, thank you. I think that what I'm taking away from this is really from the standpoint of natural resource development in areas that may affect indigenous rights is that any arrangements need to be made collectively and not with the any individuals. I think that sometimes it places a potential mineral development in a bit of a quandary between satisfying the rights of the indigenous peoples as opposed to satisfying the impositions of a government or of the national government, who may or may not recognize the rights of that indigenous community.
Correct.
John, if I may, I was just going to ask both of my colleagues here to talk about this balancing act that you just talked about, John, between indigenous rights and the interests of the government to develop the minerals. And in the consultation process, is there ever a time where it's appropriate for communities to say, we don't care how many benefits we get, we don't agree with this mining operation, we don't give our consent, and what that means?
Right. Thank you, Cassie. That implicates two important things under international law. One is the permanent sovereignty of our natural resources. So there's a very well-known principle under international law which really empowers nation states, so natural resource-rich countries, to have a say on how they would use the natural resources. So you can't remove the state, the government, from that equation, because international law recognizes it as the rightful owner, and it has the right to decide. Now, indigenous peoples demands that they are consulted, and oftentimes governments as well as some mining lawyers would confuse that with the right to veto, that communities may veto, may decide and say we don't want these investments. But we think that is an extension, and is usually a lame excuse because indigenous peoples do not necessarily veto. What they want is culturally appropriate mitigation measures that would bring about win-win situation where investors can rightfully come and get the returns on investments. The government can get taxes, but indigenous people's cultures can not be affected. They cannot be forcefully evicted. And therefore, in my views, the aspect of veto and refusing does not come. But what is needed is genuine consultation. Sometimes it may take long, but that would address worries of indigenous communities in a manner that if there are any impacts, they will be mitigated in a culturally appropriate manner.
And if I could just add, one of the things that I saw recently that I found interesting is that in the so in contrast, for example, in Mexico, there is no benchmark in the permitting process that I'm aware of that sort of brings one's mind to the question, did this indigenous community consent to the permitting and the development of their resources? And that has led to a lot of problems because essentially the incentive on the part of local governments and local actors is just to get an agreement. And it really doesn't matter who signs the agreement as long as you can affiliate them with the community. And so there's constant problems where the projects go ahead and they'll say, well, we got consent of the community, and the community says, no, actually, you didn't go through our customary system. And it's interesting in the Canadian process, specifically in two of the provinces, Ontario and Quebec, primarily that I've seen, this is where the federal government comes in, because during the provincial kind of tick the box process, the company and the government have to turn their minds to whether or not they have a form of consent. And it's usually through a vote at the community level. And this is where there's obligations on the part of First Nations participants. They actually, they have to complete the paperwork and describe the election results so that, they satisfy the terms of the permit. But having said that, if the community just says no, in all of these jurisdictions, there's going to be potentially heavy blowback against resisting the project if it doesn't fall within the legal sort of categories of Indigenous rights defenses. And in Canada, the standard cynically has sometimes just been said, well, it's been said, so all the government really has to do is consult with you. But the courts have said the duty to consult is not a guarantee to stop a project. And even if you participate, both in the US and Canada, you have to be very careful as to whether or not, you've helped the company satisfy that duty to consult, even if you object.
Good. Well, thank you all very much. And I particularly appreciate your participation here, Ellie. I know that that's one advantage that we have of modern communications is we can reach across the world and ask you to participate.